We're in an interesting moment for the court's role. For a long time, critics of the court accused it of being too active, judicially active, and of making up rights that would protect people. And the political valence there was that it was a liberal court making up liberal rights, rights to abortion, women's rights, racial equality, affirmative action, things like that. And so the way the politics worked was that more conservative Americans said what the court should do is be passive, the passive virtues, we call them. The court should only decide the cases that come before them. They should decide those cases minimally. They shouldn't be reading rights anywhere. And that's been the dynamic for a really long time. But in the last few decades, conservative organizations have organized a lot more, and there are a lot more litigation organizations that are pressing conservative issues, like the ACLU and the NAACP did for a long time and continue to do on the liberal side. There are now organizations on the conservative side. And one of the things that's really interesting is that conservative justices, I think, are being pulled in two different directions. On the one hand, they still want to say we should restrain ourselves when it comes to actively protecting liberal rights. On the other hand, I think they are interested in pursuing conservative rights, so rights to property and rights to free contract. I think those rights are back on the agenda. They haven't been there since the New Deal, since the 1930s, and I think that they are coming back in. One example, I think, of where the court is struggling to find its footing and is really thinking about economic rights is in the healthcare cases that the court has decided. And a lot of people think about those as about the national government versus the state governments, and should Congress be able to create this kind of healthcare law. And those are the terms in which a lot of the cases decided, but I think underlying that is the idea that a lot of the justices on the court don't think it's okay to require people to enter the market for health care, and they think that's problematic. And what's really rubbing them a wrong way is not Congress's power, but individuals' rights, and that they think we have some economic rights that the court has not recognized in the Constitution for almost 100 years now. There was a time when the court recognized those economic rights in the early part of the 20th century until around the 1930s, but that hasn't been the case for a long time. But there have been efforts to resuscitate that, and I think there are justices on the court who are interested in that, and so they're struggling to figure out how to come around to that and how to get that back into the Constitution and whether they want to be more activist or not. But I think the labels activist and passive are actually hard to identify, because on some issues the conservative justices are striking down laws, and on other issues it's the liberal justices who want to strike down laws. And so it's not so much about the act of striking down laws as about what those laws are about, what they're doing, and whose rights are being protected or violated by them.
As time has gone on, the Supreme Court justices have become less and less disinclined to take political considerations into account in their decisions. And it's now become popular in our time to assess the greatness or the quality of a Supreme Court judge by how much influence he's had on political affairs. And so, for example, Chief Justice Marshall is widely admired because he's considered to have built the Supreme Court into the powerful political institution that it might not have become without his influence. Similarly, Earl Warren is often praised because he and his fellow judges on the Warren Court had such a big influence on the country. Sometimes now when justices retire, the popular press will often rate them or score them according to how influential they've been, so that somebody like Justice Brennan was seen to have had a big influence on the law in the country, and so he's held to be a really great justice, whereas Justice Souter, who was a pretty quiet guy and didn't make a big name for himself as a world changer, is thought less highly of, even though the jurisprudential views of Brennan and Souter were very similar to each other. Some people think this is the inevitable result of separating the judicial and legislative functions under a written constitution, that the court was inevitably going to end up deciding cases with important political consequences, and therefore that they would and should become sort of part-time politicians, or that the job of the judge was as much political as legal in nature.
Institutionally, I think the biggest challenge for the court is that people are finally seeing it for what it has always been, which is a partisan and partisanly situated institution. That there is, people talk about the politicization of the court as if this is something that has not always been the case, but it has always been the case. And you can't talk about Marbury versus Madison without talking about the election of 1800, without talking about Federalists and Jeffersonians, and then you can't talk about Bush versus Gore without talking about the election of 2000, without talking about Democrats and Republicans. The court is and always has been a political institution staffed by political actors. Now, that doesn't mean they're political in exactly the same way that presidents or members of Congress or governors or anyone else are political. There's a certain role morality that goes with being a judge. There are certain ways you have to talk. You have to write opinions that sound like judicial opinions. And because you have to talk that way, that means that there are certain things you can't say, right? There are certain results that simply can't be squared with the way that judges are expected to talk. And that puts real constraints on them. But all political actors have constraints on them that are created by their role and by their situation within the political system. I think the challenge that the court is facing is that, at least if public opinion polls can be trusted on this, more and more people seem to recognize this about the court. And that's a challenge for the court more than for the other institutions, because the court depends for its power on public perception more than the other institutions, right? It doesn't have the power of the purse like Congress does, doesn't have control of the army like the president does. What it has is respect, and that respect means that if a president actively disobeys the Supreme Court, he's likely to face consequences, that he's likely to face a public backlash. If the public turns on the court, then a president or a Congress that simply ignored the court, the way Jefferson threatened to do to the court in Marbury, would no longer face those consequences, and then a president might be more willing to consider doing that. So there's I think the threat to the court might simply be a more accurate understanding of how it does its work and what kind of institution that it is.